Hello, my name is Jason Rubens, and I am the founding partner of Rubens and Kress. In a workers' compensation case, you are often entitled to compensation for your permanent disability. The Illinois Workers' Compensation Act sets forth a formula for calculating an injured worker's permanent disability. If the injured worker has permanent restrictions that prevent him from returning to the job he was working prior to being injured, he may be able to proceed on a wage differential theory or a permanent total disability theory. Because these claims are often worth more money, insurance companies do everything they can to prevent them from being successful. Their methods are often harsh and unethical. Sometimes they obtain a doctor to contradict the treating doctor's opinion that the claimant has permanent restrictions. These doctors often ignore the objective medical evidence when they render their opinions. Other times, the insurance companies cut off the injured worker's benefits for no reason at all, although they come up with a ridiculous explanation to justify their decision. This is not allowed under the law, and there are penalty provisions in the Illinois Workers' Compensation Act to discourage this type of conduct. However, in my practice, I see this type of behavior quite often. In fact, there's an industry term for this type of behavior. It's called starving the claimant out. They hope that the injured worker will become desperate and take a much smaller settlement just so that they can put food on their table. If you have an injury that you suspect is career-ending, I cannot emphasize the importance of obtaining an experienced and aggressive workers' compensation attorney to make sure all of your rights are protected and that the legal theories that make your case the most valuable are pursued.